All right, here's the full contract draft. Agreement for Acquisition Specialist Services. This agreement is made and entered into as of date by and between Acquisition Specialist's name, hereinafter referred to as the Acquisition Specialist, and buyer's name, hereinafter referred to as the buyer. 1. Services provided. The Acquisition Specialist agrees to identify suitable investment opportunities, conduct due diligence on those opportunities, including but not limited to financial statement analysis and verification of business legitimacy, negotiate the terms of the acquisition on behalf of the buyer, including but not limited to purchase price, closing date, and any contingencies, manage and facilitate the exchange of required documentation throughout the transaction. 2. Buyer responsibilities. The buyer agrees to provide necessary information and documentation to the acquisition specialist, pay the agreed-upon fees for the acquisition specialist services, cooperate with the acquisition specialist throughout the process, secure any necessary financing for the acquisition. 3. Fees. The buyer will pay the acquisition specialist a fee of 12.5% of the total purchase price of the acquired property. This fee will be paid in 2 installments, 5% upon the signing of the purchase agreement and 7.5% at the closing of the transaction. If additional services are required beyond the standard scope of work, the acquisition specialist and buyer will agree upon a separate fee structure for those services. 4. Ownership and profit sharing. The acquisition specialist will receive a 10% ownership stake in the acquired property or business, plus an additional 25% of the net profits generated by the business after all initial financing obligations have been satisfied. 5. Operational responsibilities. If the acquisition specialist is involved in the day-to-day operations of the acquired business, their specific duties will be outlined in a separate operating agreement. 6. Confidentiality. Any information shared between the parties involved should be kept private. This includes things discussed or written down while negotiating and finalizing the deal. This information can't be shared with anyone else without written permission from the other party. 7. Dispute resolution. If there are any disagreements about this contract, the parties involved should try to work it out through good faith negotiations. If they can't come to an agreement, they can decide to go to mediation or arbitration. 8. Termination. Either party may terminate this agreement if the other party doesn't follow the terms of the contract. The party who wants to end the contract must give the other party at least 30 days written notice. Entire agreement. This agreement constitutes the entire agreement between the parties and supersedes all prior or contemporaneous communications, representations, or agreements, whether oral or written. Governing law. This agreement shall be governed by and construed in accordance with the laws of the state. Counterparts. This agreement may be executed in any number of counterparts, each of which shall be deemed an original, but all of which together shall constitute one and the same instrument, in witness whereof the parties have executed this agreement as of the date first written above. Acquisition specialist signature. Buyer's signature. Important note, this is a basic contract template and may not address all potential legal issues. It is strongly recommended that you consult with an attorney to review and revise this agreement as needed to ensure it meets your specific needs and complies with applicable laws.